on, give me 1 second. Okay, can you guys can hear me, right? Thumbs up if you can. You're good.
It's
Awesome, good.
I am recording now. I'm admitting people at the same time, but I have to mute them as well. If people could already mute themselves first, so I can continue to admit people in.
All right. Excellent. Can you guys see my screen? Thumbs up. Okay, good. All right. So as I said, the session has been recorded and will be available after the session to be sent out for everyone for training. We are going to have a Q&A at the end of the session. So again, hold your questions until the end. I'm sure we're going to answer a lot of your questions along the way that pop into your heads. You'll be able to use either the raise your hand feature or type your question in the chat, or if you raise your hand, we'll call you in order so we can answer your questions. There will be a quiz. Ooh, there'll be a quiz emailed after. Not today, probably within the next few days, we have to put it together. We're going to require that all agents that are doing rentals, that wants to do rentals moving forward, will need to complete that quiz in addition to completing this training today. The recording will be available. All the links will be available, and it will be permanently available if you want to go back to a reference and the material we discussed today. So the information you have today in the slides will all be available to you for you to be able to consult as you move forward doing rental business in the future. Okay. Okay. Rentals, don'ts and do's. You guys notice I reversed that, don'ts and do's, because the don'ts, the things we don't want you to do, are so much more important than the things you should be doing when it comes to not staying out of trouble. So somebody just texted me asking if they'll lose their license if they don't attend the class. No, you're not going to lose your license if you don't attend the class today. However, we are going to ask and require that you get the training as soon as you can and complete the quiz when it's sent out to you so you can continue doing rental business. So the first thing and the most common thing that happens when it comes to rental issues, Mark, can you mute yourself, please? Rental issues are going to be discrimination. Discrimination and acts of discrimination is the most common occurrence that we see when it comes to rental issues that we encounter as agents. A landlord can never deny renting an apartment to any of the following protected classes. Now, obviously, there's the ones we all know. Nationwide, federally, there are 7 protected classes: race, color, religion, national origin, sex, disability, familial status. That's the federally protected classes nationwide. We all know this. We all know we're not supposed to discriminate. We don't discriminate when it comes to working with that. In New York State, there are 7 additional protected classes in the state of New York. Those are age, which means you cannot discriminate against somebody that wants to rent based on their age, provided they're of legal age. Marital status, sexual orientation, military status, gender identity, domestic abuse victims, and source of income. These are the 7 New York State protected classes we must abide by. We're going to get into some details when it comes to running through those. In essence, most of them are self-explanatory. Source of income is usually one of the ones that's most confusing. And what that means in essence is if you have a tenant that wants to rent an apartment that is approved by a voucher, the state, some sort of program, anything that provides the full amount of rent for the apartment, the tenant cannot be denied rental of that apartment because of where they're getting the income to be able to pay for the apartment. In addition to that, New York City, the 5 boroughs, if you work real estate rentals in the 5 boroughs of New York, and that does include Staten Island, even though we don't think that's a borough. Citizenship and lawful occupation are also protected classes. So you cannot deny somebody a rental based on one of these additional protected classes within the 5 boroughs of New York City. So you've got the federal 7, New York State, the entire state 7. That would apply to doing rentals in Westchester. If you did a rental in upstate New York, anywhere that you're licensed to do rentals, those 7 New York State protected classes would apply. And then in addition to that, the New York City, the 5 boroughs have got the 2 additional protected classes that we must abide by: citizenship and lawful occupation. So for example, if you're doing a rental in Nassau or Suffolk County, the last 2 obviously will not necessarily apply, but I will still caution you that if you are going to do a rental outside of the 5 boroughs on Nassau, Suffolk, or Westchester, that you be careful when it comes to these 2, even though they're not necessarily the law within those areas. You'd want to be careful to not tread on that if somebody is in one of those situations. So the key would be to not get into that situation anyway. I think at some point, these 2 would become protected classes in Suffolk, Nassau, and Westchester anyway. So it's just a matter of time before that happens. Additional restriction when it comes to rentals. A landlord can never make a blanket statement saying they do not want a tenant with any criminal record or criminal background. A landlord just can't say to you, hey, Shamir, I don't want somebody who was ever arrested in the past, no, regardless of what it is. Now, it's not a protected class in the sense that somebody who has a criminal background is protected from not being violated. However, these situations, if a tenant mentions to you that they've got a criminal background, you should immediately inform the landlord if this happens during the application process. And they don't have to tell you, because we're going to be doing a background search anyway, so they don't have to tell you, I've got this issue or so. But if they were to mention it and you're working for the landlord, you should immediately inform the landlord and recommend that they speak to their attorney before you respond to the tenant in any way pertaining to the apartment. So it's important that you don't just randomly answer a question when or answer one of those questions if somebody asks you if it's okay if I can rent the apartment because I've got this situation in the past. You must speak to the landlord, have the landlord speak to the attorney, speak to me, speak to your broker or manager, and get clarification first before you respond to something like that. Like I said, inform the office manager or broker whenever something comes up like this, so you can make sure that you answer it in the right way. In addition to that, a tenant cannot be denied renting an apartment if they've had a previous eviction. That is something that is very important. It was passed in the new law in the Tenant Protection Act back in 2019. So if a tenant have had a previous eviction on their record, they cannot be denied renting an apartment because of that. We're going to get into that a little bit further as we go into tenant background searches a little bit further on. Hold on one second. Okay. So what to do if a landlord asks you to break the law? This is probably going to happen at some point. You sit for a listing appointment with the landlord and he says to you, hey, Shamir, I don't want X, Y, and Z. I don't want this tenant. I don't want that tenant. We're responsible to know what the laws are. We're discussing the laws today. You know what the laws are because you're a licensed professional. If you don't or you don't remember, you should always stay in touch and stay up to date with the laws. If a landlord says to you, Shamir, I want you to break the law, by giving you an advice that you know or you should know that's against the law, you must immediately inform the landlord that what he or she is asking you to do is against the law. Do not hesitate to tell them that what they're saying is against the law. Do not sugarcoat it by saying, I'm not sure, let me check. You must know what the laws are and you must inform them immediately that they're violating the law. If they're not sure or they disagree with what you're telling them regarding the laws, then you should recommend in writing, ideally via email, that they must consult with their attorney to answer any questions they have pertaining to the rental law. You can also provide them a copy of the law, as you know, with a copy of the rental laws, discrimination law, fair housing laws, the Tenant Protection Act. Everything is available in writing. So you can provide that to them so they can have clarity when it comes to the law. Sometimes a landlord can be misinformed. If after you inform them that what the laws are, if they still insist on you breaking the law, then you must inform them that you have to follow the law, otherwise you cannot represent them in locating a tenant. What does that mean? That means if Mr. X says to you, hey, Shamir, I don't want a couple renting this apartment if they're not married, or I don't want children in the apartment if it's a one-bedroom apartment. You have to tell them it's against the law, and if they insist that they don't want that, then you must not represent them. You have to refuse the listing. If you have the listing already and somebody says to you, I don't want X, Y, and Z situation that is against the law, then you must tell them they're breaking the law. And if they insist on going down that path, then you have to let them know, I'm sorry, I cannot represent you. And you have to release the listing. I know it sucks because we're losing money if we're not representing somebody for a rental, but your license is worth a lot more than any rental commission you can ever get. That's very important, guys. If you have a situation where you've been asked to break the law, you must not work for that person. You must also remove all advertisements you have out there regarding the apartment. So that includes social media ads, advertisements online, obviously releasing the listing from the MLS. That's critical. And we want you to immediately let us know what happened. So an email, a call, a combination of a call and email to us, to me, to the office manager, in writing, notifying what happened, the details of what happened, and also the information, the contact information for the landlord. We'll need that on file. So if there's any issues moving forward, we'll have everything we need to be able to protect you and protect the office when it comes to that situation. If a landlord asks you to violate the law in a private discussion, do not go back and discuss that with the tenants. Inform the landlord what the laws are and what they're supposed to do. And if they don't follow, then remove the apartment from the rentals, release the listing. Do not work with that apartment any longer, but do not discuss the violation with a potential tenant. If you had a tenant that had an interest in the apartment, you can move on to show that tenant an additional apartment. Just tell the tenants the landlord took the property off the market. What happens if a landlord asks you to break the law while showing an apartment to a tenant? Now, that's a very, very touchy situation. And this has happened in the past. And it's a very, very dangerous situation to be in. It might happen. Best practices I recommend if you show an apartment, to never, ever show the apartment in the presence of the landlord. This way, the tenant can have privacy look at the apartment, and you can never have a situation where something like this can occur. If a landlord were to ask you in front of a tenant to break the law, you must immediately inform the landlord that what he or she is asking is against the law. In the presence of the tenant, in front of the tenants, you should tell them it's against the law. I cannot do that. You're breaking the law. You need to let the landlord know and let the tenant hear that you inform the landlord that they're breaking the law. Let the landlord know that it's against the law and your company do not discriminate and we always follow the law. Inform the landlord that they must follow the law, otherwise you cannot represent them in locating or getting a tenant. And this can happen in front of the tenant, especially if the landlord were to violate the law in front of the tenant. If they violated the law separately, where in private with you, then you have to follow the rules, like I mentioned before, and let them know what the laws are. But you can keep that conversation separate from the tenants. If they were to violate the laws in front of the tenant, then you can let them know in front of the tenants that they're breaking the law. Immediately inform the office, myself, the broker, the manager. We've got what's called errors and omissions insurance in our office. It does not protect you if you break the law, but it does protect you if somebody asks you to violate the law and you follow the laws like you're supposed to. Our E&O policy protects you in that scenario, but we must inform the company that this has happened, so they can take the appropriate steps to protect you. So if you were to be in a situation where somebody asks you to break the law, you must immediately inform us at the office what happened. Not just a phone call, not just a text message, a phone call followed with a detailed summary of what happened via email must take place so we can take the appropriate steps to protect you and protect your license. If it's your listing and a landlord asks you to violate the law in front of a tenant, you must immediately remove the listing from the market, from the MLS and all advertisements online. Do not continue to show an apartment to anyone where the landlord has asked you to break the law. If that's happened and you continue to do that, we'll have no choice but to terminate your license also. Because if you are willingly shown an apartment where a landlord asks you to break the law, we're going to have a zero tolerance policy when it comes to that. So know the laws, know when the laws are being broken, protect your license, inform the landlords they're breaking the law, and do not represent somebody that is asking you to break the law. And this goes back to all the protected classes we discussed before, and is going to go forward to the Tenant Protection Act we're going to speak to in a few minutes regarding deposits, security deposit, background searches, occupancy amount in terms of number of people in an apartment. All those things are going to be discussed in a few minutes. This all applies to everything we spoke about a few minutes ago and what we're going to talk to moving forward. If it's not a broker's listing that you're showing, immediately inform the listing agent in writing via email and copy myself or the broker in Bayside, that's Lou, or managers, Susie, Jessica, Gloria in Bayside, and also copy the listing broker's manager in that same email. It is your duty to inform the other listing agent that their client, their landlord, is violating the law. Then you do not shut an apartment any longer, but your responsibility, if it's not your listing, terminates after you've informed the listing broker that their landlord is violating the law. If it's your listing, like I mentioned before, you'll remove it from the market and no longer represent that landlord. Advertising don'ts and do's. You guys notice I reversed it, don'ts and do's, because the don'ts are a lot more bigger issue than the do's. Never say walk to the subway or shops. I know it sounds harmless, oh, you can walk to the subway, just 2 blocks walk to the subway, 2 blocks walk to the shop. That's discriminating against somebody with a disability. You cannot say walk to the subway. Never say ideal for a couple, because that's being discriminatory against someone's marital status, which is a protected class. Never say no kids, because that's discriminating against someone's familial status. Never say close to church or synagogue, because that could be discriminating against somebody else that's not going to a church or a synagogue or not religious. It could violate their religious status. Never say no pets, because some folks are entitled to have a service animal or a medically approved emotional support animal. So you can't advertise no pets. Now, the exception would be in the case of a co-op where their rules are no pets, but even in that situation, you should not advertise no pets in your ad. The application process for the co-op board would detail that information, and it will be their responsibility, the co-op board, to alter their no pet policy in the event somebody is making an application that has a service animal or a medically approved emotional support animal. It's not going to be your responsibility, it'll be the co-op board's responsibility.
So, Mayor,
Your ads, as a matter of practice, should stick to only describing the apartment. Wonderful 2-bedroom, 2-bath, second floor unit, recently renovated with stainless steel appliances, and yellow tile bathrooms. I don't know, like just stick with the description and nothing else. You don't need to put walk to the subway. If you go online today and you run an ad, the website is going to provide the distance to the closest subway, the walk score, and details about the location in the area. So you don't need to take the risk of saying the wrong things in your advertisements. The amended pet policy law that I mentioned before regarding the emotional support animal is referenced right here. And it says basically the Division of Human Rights has found in appropriate circumstances that permitting a person with a disability to maintain an animal as a reasonable accommodation is necessary for a person with a disability to use and enjoy a dwelling. So if you have a landlord that says to you, hey, no pets, you have to advise the landlord, I'm sorry, there are exceptions to the law that says that if a person has a service animal or a medically approved emotional support animal, then you cannot deny them the right to rent that apartment. If a landlord insists that they want you to advertise no pets, then you must, like I said before, refuse that listing and do not work with that landlord because they're asking you to violate the law. They must be open to allowing pets for these 2 exceptions, and these 2 exceptions only. Rental application do's and don'ts. I actually switched that around. So the Tenant Protection Act that was passed in 2019 covers a lot of these items. In your agent resources folder in Jackson Heights, and I'm sure in Bayside, we have links to all the forms and all the information when it comes to the Tenant Protection Act for you to be able to reference. This is going to be a summary of the most important things when it comes to that act pertaining to residential real estate rental. An agent cannot charge a tenant more than $20 for a background search. A copy of the search must be provided to the tenant after it's done, even if the tenant do not rent the apartment or is denied of renting the apartment. It must be provided to the tenant. If a potential tenant provides a background or credit check within the past 30 days, the fee must be waived. You cannot charge the fee. You can still get them to run the background search with the approved company that we use, but the landlord or you, the agent, will have to pay that fee. A landlord cannot require a tenant to pay more than 1 month's rent as a security deposit. No exceptions. If a tenant has an approved voucher to cover the rent, the landlord cannot require the tenant to provide financial statements, tax returns, W-2s, pay stubs as part of the application. So if a tenant has an approved voucher to cover the full amount of the rent, or in the case of a work Section 8 program where they are required to pay a portion of their rent up to 30% from their employment, if they're approved to cover the apartment within those 2 criteria, you cannot ask them to provide financial background searches in terms of taxes, tax return, W-2s, pay stubs. It's not allowed. A landlord is allowed to require a minimum credit score for all potential tenants. So a credit check is allowed, which is also included as part of the background search. This standard must be the same for all applicants. A landlord cannot say, oh, well, wait a second, your income's not enough, so I need you to have a better credit score, or your income's very high, so it's okay, I can accept you with a 680 FICO. The standards must be the same for all tenants, no exceptions. A landlord cannot request an additional security deposit for pets. So if the landlord is going to allow a pet, they can't say, well, the tenant must pay 2 months of security. That is against the law. It has to be only 1 month of security. So these are discussions you should be having with your landlord when you list an apartment, so they understand what the laws are, so they do not instruct you when you have a tenant that has one of these circumstances. They don't ask you to break the law. A landlord cannot request an additional move-in deposit above 1 month security. So let's say a tenant's moving in and they've got a lot of stuff. A landlord cannot say, well, you need to pay me 2 months of security in advance, and then I'll give you 1 month's back. That's not allowed. It's against the law. The names and ages of children, minors, are not required to be provided on a written application. You can ask a tenant, how many occupants will be in the apartment. Children, they can discuss the ages with you, but it's not required to be provided in a written application. On the few moments where you're allowed to do an approved sublease, in other words, I'm a tenant, I want to sublease my apartment. I've got written permission from my landlord that I can do so, and I hire Mark to find me a tenant to sublease that apartment. Mark can do so because I've got written permission from my landlord to sublease the apartment, but Mark cannot charge that tenant the application fee. I'm responsible to pay those fees because we're subleasing the apartment. Background searches. As an agent in Keller Williams Landmark, we've contracted with a company called National Tenant Network, which is a legally approved background search company that follows all the laws when it comes to background searches. They don't do the searches that are not allowed pertaining to the laws. We've sent this out previously to all agents. We're going to send it out again today after the class. The company is called National Tenant Network. Their searches are capped at $20 as required by law in New York State. The instructions are in the agent resources folder, and we're going to be sending those back out after the classes today. Christina, can you make a note of that? So this way, when you get the slide, you'll have the background search link and the forms that needs to be completed, the background searches. You cannot use your own background search companies anymore. You must use this approved company we have with the office. They follow the laws. They'll protect your license. You're not going to violate the tenant's rights by using another company out there. You can't ask your banker's buddy to run someone's credit when it comes to a tenant screening. Not allowed anymore, because they're going to seek information that's a violation of the tenant's rights under the Tenant Protection Act. Occupancy do's and don'ts, or don'ts and do's. The landlords must follow HUD guidelines when it comes to occupying an apartment. Absolutely. HUD guidelines states 2 persons maximum per bedroom are allowed. If you're renting a studio apartment, a couple is permitted to occupy that apartment. So if you have a studio apartment, and I've had this discussion before with other agents, you cannot say, my landlord doesn't want more than a single person. That is against the law. You can't advertise single person preferred, single person only, ideal for a single person. None of that. If you recall, I said earlier, stick with describing in your ads only information about the apartment, nothing else. Do not make any reference to occupancy limits, who should occupy, none of that. Children are allowed to share a bedroom. However, teenage kids of different sexes are expected to have their own rooms. So if you have a situation where kids are older, then naturally that tenant may look for a 3-bedroom as opposed to a 2-bedroom. But just so you know, if you have a 2-bedroom apartment, the maximum occupancy allowed are 4 people. with the exceptions of all the kids, then there'll be a different scenario. A couple with an infant child, a newborn, is allowed to occupy a one-bedroom apartment. Security deposit don'ts and do's. Landlord must return security deposits to a tenant within 14 days of vacating an apartment. No exceptions. That's new with the Tenant Protection Act 2019. Or they must provide a written reason within 14 days why they are holding on to the security deposit. The tenant has a right to complain with the city if one of the above does not happen within 14 days. There is a form available online. It'll be in the agent resources folder that if you wanted to provide it to a tenant or a landlord, if they have an issue so they can understand what the laws are, so they know to make sure that they follow the law. Agency disclosure. Just so we're clear, because sometimes I get this question, surprisingly get this question more often than I would like to as a broker. You can never represent both the landlord and the tenant. As a company, we do not allow that. You have to decide who you're representing. It's got to be either the landlord or the tenant. The agency disclosure must be signed before showing a tenant an apartment, either electronically or in person. Has to happen at first contact, which means before showing the apartment, before getting into discussion in detail about the apartment. So a tenant contacts you, you should start in that first conversation having the discussions about agency and fair housing with them immediately. Can you guys see that form? Thumbs up if you could. Okay, this is the most recent and approved agency disclosure form. I'm gonna run through real quick how to fill it out, because oftentimes I find agents do not complete this properly. Name goes here, company name goes here. When I say company name, I mean the full name of the company. So not just Keller Williams Realty, not just KW. It has to be Keller Williams Realty Landmark 2, or in the case of Bayside, Keller Williams Realty Landmark. If the names are too long, you could abbreviate the KW, but the rest of the name must be fully completed. Your correct name must be obviously in the name of the licensee. If you're working with a tenant, you're going to select the tenant section. Tenant's agent, if you're working as a tenant's agent. This is because you're working with a tenant only, not as a landlord. And you'll select advance informed consent to dual agency with designated sales agent. And the reason why you do that is because you may sometimes want to show an apartment that's within the office listed by the office. And because that apartment is in the office, then you need to do the advance informed consent so that the tenants can know you're representing them, but the listing agent of the apartment is representing the landlord. We're just going to go into that form. To back up, if you're representing the landlord, when you take the listing, you'll select landlord as landlord's agent and advance informed consent to dual agency. That's all you're going to do in this form. It must be signed by the landlord or the tenant, but not both of them in the same form. Because again, you're never doing dual agency when it comes to rentals. And of course, dated. Give me 1 second.
Could you go over that again, Shamir?
We're gonna go, you want me to go? Okay, no problem. Just give me 1 second. Did you have a specific question?
Yeah, I mean, most of the time, I have a listing and I'm renting it out. So how can I do that?
So if you have a listing, you're renting it out, you're gonna provide the agency disclosure where to the tenant, after you met with the landlord and it's signed, the tenant comes to you and say, hey, Robert, I want to rent the apartment. You're going to tell them, just need to let you know, I'm representing the landlord in this transaction. So the tenant is going to sign this exact same form that you're going to check off here, landlord's agent, advance informed consent to dual agency, click on tenants, and the tenants will sign at the bottom. So the tenants are going to know that you're representing the landlord. When it comes to agency, you have to pick in advance who you're representing. In this case, if you have the listing, you're representing the landlord, and everyone that you deal with when it comes to renting the apartment has to know who you are representing. So if you have the listing, naturally, every person you show the apartment to would sign the form acknowledging that they know you're representing the landlord and the landlord only. You're not representing the tenant in that situation. However, if I have a listing and you contacted me because you've got a tenant that wants to rent that apartment, then Robert, you would have had that tenant fill out and sign as a tenant's agent because you're representing the tenant as a tenant's agent. Does that answer your question?
Yes, is that true too if I'm showing someone else's listing in my office? Same thing?
Correct. That's where the designated sales agents will come into that, because you're going to fill out as a tenant's agent, and tenant is going to sign understanding that you're representing them, but the other agent, who's the listing agent, is representing the landlord.
Give you a check for.
Let's just hold the rest of the questions as we move forward, guys. So give me 1 second.
Thanks, Shamir.
You got it. So when it comes to agency, follow the 4 Ds. This is a very common practice we do. Decide who you're representing in advance. Disclose your role, so this way they understand who you're representing. In the case like Robert just said, he's going to disclose to the tenants that he's representing the landlord, or he's going to disclose to the listing agent that. I got lost there for a second. Can you guys hear me back? Thumbs up. Disclose your role, documented by getting the agency disclosure signed in advance at first contact, and do play your role, which means if you're representing the landlord, don't say things that violate that representation by making the tenant feel that you're representing their best interest. No, you obviously owe the tenant honesty and clarity and transparency, but your fiduciary responsibilities can be to your client, the landlord, if you're representing the landlord. Same thing when it comes to the fair housing disclosure. This is passed as of last year, June. This must be signed also at first contact. So as a matter of practice, you should always be practicing agency and fair housing at the same time. Whenever you meet a tenant or a landlord, a client, at first contact, you must get them to sign both forms at the same time. Same thing with this form, self-explanatory. It's available. You'll fill out your information, the name of the company, the names of the parties that are signing the form, and then their signature. This form applies to buyers, sellers, tenants, and landlords. You also must provide the fair housing notice to landlords and tenants at first contact. So if you meet a tenant and they're signing the agency disclosure and the fair housing disclosure, then you must provide them a copy of this fair housing notice so they know what their rights are. The same thing applies to a landlord. Lead paint disclosure, another common problem we see when it comes to rentals and sales, must be provided at the time of application to a tenant. Not at first contact, but at the time of the application. So as a matter of practice, you show the apartment, the tenant's interested in the apartment, they want an application to complete, to submit for consideration for the apartment. At the time of submitting the application to them, you must provide them a copy of the lead paint disclosure that was signed and initialed by the landlord, disclosing what their position is when it comes to lead paint. That lead paint form is available in our agent resources folder. You must also provide a tenant with a copy of the lead paint pamphlet the same time you provide them a copy of the lead paint form that was signed by the landlord. The lead paint form is the only form that the landlord and tenants are going to sign on the exact same form. Disclosures, agencies, they're going to sign on separate forms. but lead paint forms must be signed on the same. So the landlord discloses what his position when it comes to lead paint is, and the tenant gets to see that and sign on the same form, and they'll take the option of either their right to, they'll either they'll take the information, check off that they received the pamphlet and they receive copies of the information from the landlord, and they'll sign at the bottom, and then you as the agent will sign an initial also to complete the form. Legal apartments. This is a common problem in Queens because sometimes it can be confusing when it comes to apartments being legal. We as agents, licensees, are only allowed to rent legal apartments. No exceptions, no if, no ands, no buts. We're not allowed to rent rooms. I've seen this before and I've had to correct it when it comes to some agents. Advertising on social media, rooms for rent. You're not allowed to rent any apartment that's illegal. Just so you know, if you rented an apartment that's illegal and collected a commission that's illegal, and a tenant were to sue, they can collect 4 to 6 times the damages of the amount of the rent from you, the agent, for renting an illegal apartment, in addition to the landlord being also liable. It is your responsibility to make sure that you confirm that the apartment you're listing is legal. You can never rent basement apartments. A landlord must provide, this law was passed in 2017. When renting an apartment, a landlord must provide a copy of the certificate of occupancy to show the apartment is legal, or a letter of no objection from buildings that are older, as many buildings you have in Queens and Brooklyn, or a copy of a search from a title company or from Department of Buildings stating that the home predates the CFO requirement, but it's a legal apartment, legally allowed to be rented. This document must be attached to the lease when signed by the tenants. That's required as a part of the lease when you sign with the tenants, for them to know what their rights are when it comes to the legality of the apartment. Leases. We as agents are not attorneys unless you are an attorney acting as an agent, which also is allowed. If we're agents, we're never allowed to prepare leases. Never, ever, ever allowed to prepare leases. Landlords or their attorneys can prepare leases. I usually recommend landlords to either speak to their attorneys or obtain a copy of the generic Bloomberg form lease that's available online so they can prepare the leases when it comes to a rental situation. We are, as agents, allowed to facilitate the lease signing, either in person or electronically. We're just not allowed to negotiate or change or prepare the leases when it comes to terms and information on the lease. Rental commissions. We're never allowed to accept a commission payment directly to our accounts as agents. So if you rented an apartment and the tenant says, especially in today's world, said, hey, let me Venmo you the commission? No, that's not allowed. That must be transferred directly to the office. The office has an online Zelle direct transfer account. It could be done. Payments can be sent to the office directly. Payments should be, I highly recommend, certified funds made payable to the company name. If in a few circumstances where you accept cash payments, you must provide a receipt to the tenant and bring cash to the office as soon as possible. Open listings, common in our rental world. You are allowed to advertise open listings, but you must get written permission from the landlord to advertise the open listings, which means something in the form of an email or any paperwork in writing allowing you to be able to advertise the unit is allowed. When advertising an open listing, keep in mind a tenant that calls you on that ad is going to assume that you're representing the landlord. So even though you don't have a signed listing agreement, you are still indirectly representing the landlord. In those situations, you must also, again, get the agency and fair housing disclosure signed by the landlord. All the laws pertaining to representation when it comes to discrimination and the things we discussed before still applies when you're advertising an open listing. Okay, 45 minutes, perfect. Let's jump into the questions. I'm sure there's a ton of them. So Christina, let's do the following. You can start either with a written question, and then we can jump into somebody to raise their hand that has a question.
Well,
One
Steph,
after the other.
but Shamir, quickly, do you want to
Mhm.
just stop sharing your screen too, so maybe you can also see it as well? Do you want to just alternate, or so?
We're gonna alternate, yes.
Yeah, first and
We're
foremost.
gonna go in order of people to raise their hands. So
Okay,
let me look
another.
into the chat.
So I do see Robert raised his hand, but also earlier Christine Coley had raised her hand. So Robert can also go, but everybody, if you could also use the raise hand emoji like Geraldine has up right now. Okay.
Okay, who's
So
going
we're gonna
first?
go. Let's go with Anastasia first because she did ask a question on 11:13. She
Okay.
was the very first person, and she said, "Are we liable for what the landlord says if they are talking directly to the prospective tenants?"
Absolutely. I mean, is she speaking in terms of in front of her or
Oh, if
separate?
they have a, sorry, just to clarify, if they have a conversation, let's say they want to, they have additional questions for the prospective tenant and they are talking on the phone without the agent being present, are we still
Well,
liable?
you should never allow prior to a rental being completed. If you're in the negotiation space, working out details, you should never allow them to speak without you being present. And so, to answer your question, if you're responsible, if you're not involved in that discussion, and the landlord says the wrong thing to the tenants, and the tenants went ahead and filed a discrimination claim, and you're the listing agent, then you would be responsible. So that's why you don't want to have them have a discussion alone without you being present. So if they were to have a discussion and said the wrong thing, then you'd be in a position to correct the landlord about what the laws are. Okay, let's jump to a raised hand question.
Really quickly, Robert did raise his hand, like physically raise it. So
Go ahead,
Robert,
Rob.
you next, and then Geraldine.
Hey, Shamir, thank you very much. And Christina. I got two problems, but I'll give you one, and if you can't, the other one. With a homeowner that it's a legal two-family house, there are a little more things that somebody that lives in the house could restrict the tenants from, correct?
Incorrect. So, I mean, that's a great question, Robert. And so let me just clarify that. I'm glad you asked the question. I'm sure that's pretty sure to come up. So you're referring to something called a Mrs. Murphy exemption, which is basically if an owner resides in the premises, they have more flexibility in terms of who they can say yes and who they can say no to. Let's be clear. The minute an owner hires you to represent them as an agent, those laws do not apply. So you cannot, if an owner says to you, Robert, list the apartment by I don't want tenants with kids, you cannot take that listing because they're asking you to break the law. If they advertise the apartment on their own privately and they rent it on their own without their broker, then they have the flexibility of taking advantage of those exceptions that are afforded to them. But the minute you're hired as a broker, those rules go out the window. There's a lot of misconceptions when it comes to that. People have said that to me before, thinking it was a matter of fact. It is not. The law is very clear. If you're a licensee representing a tenant, then you must follow the laws, and you cannot use those exceptions. What was your second question?
Oh, great, Shamir. I've got some fellow that I met in church. He's about 60-something years old. He was just released from prison 30 years ago. He was in jail for like 30 years for sexual something or other.
Mm-hmm.
And he's living in some kind of shelter. And they're willing to, he's got some agency willing to pay for everything.
Okay.
But how do I go about, how do I represent him to a landlord? What do I have to, I know you touched on it, but I'm like afraid, I want to help the guy, but I'm afraid I don't know
You
what to
just
do.
you just show him the apartment that he's approved for the amount and put in the application with the voucher that he's approved for, and that's it. there's not a discussion when it comes to anything regarding the past, because he's not currently, in jail. He's out of jail, so he's already served his time. So you simply show him the apartment. The discussion about his past has no bearing when it comes to him looking for the rental. You simply show him the apartment for the approved amount that he's approved for. So if he's got a voucher or an approval from the city for 1,500 for a 1-bedroom, you show him 1-bedroom apartment for 1,500, and that's it.
Okay, Shamir, it's in Westchester. It's kind of the same up there.
Mm-hmm.
But the thing is, don't you have to say that he was a sexual offender, even though it was 30 years ago, or you don't have
No,
to?
so if he's registered by a sexual offender, then he would be registered online. It'll be up to the owners if they wanted to inquire to search out that information. Now, there are disclosures that are required when it comes to registration for a sexual offender. So he'll need to make sure that he's following the laws when it comes to that, and his disclosure when it comes to the areas, where he has to alert people or the authorities or whatever. But when it comes to the bearing of the apartment, it doesn't necessarily have to be something that affects your decision in terms of showing to him. What I would recommend in this situation, especially this is one of the situations you need to be careful with, is you need to make sure that if he has an attorney or you have an attorney that maybe you dealt with in the past that he wanted to get clarity on, then you could certainly have them reach out. Or if you have a landlord that you want to get clarity on, have them speak to their attorney to clarify what their rights are when it comes to that situation.
Okay.
Now, that's a tough one, obviously, right? Because it's a
Well,
situation where there's going to be concern, but those are the situations where you never want to speak out of turn. If you're not sure, you check, you clarify. We have an attorney with the state through NYSAR that can answer many of those questions for us. So if I'm not available, or Lou's not available, or Gloria or somebody else in the office, they can give you an answer. We've got the state attorney, Anthony Gatto. Christina, can you make a note to provide that also as part of the in the agent resources?
Contact info.
You guys are welcome to call. They will take your call and always answer your question when it comes to anything pertaining to the laws that we have to follow. Okay, next question from the chat.
Oh, Shamir, real quick. So in other words, when I show this guy an apartment, I don't have to tell the landlord about his sexual thing. Just about where the money's coming from, how he's getting paid. That's it.
And that you didn't have to set it in advance. You just have to show the apartment and provide that as part of the application.
Okay, thanks, Shamir. I'm sorry to tie up the.
You got it. Next question in the chat. Who was
Well,
that, Christina?
the one at 1122 was a question that pertained to what you're talking about at the time. And Stephanie asked, can we say the train is 2 blocks away?
You can say the train is 2 blocks away. You just can't say walk to the subway or short walk or quick walk.
Okay, awesome. Geraldine is next. She raised her hand first.
Hi, Shamir. My question is, how do we understand an applicant's financial situation without breaking the fair housing laws? So like if they're on unemployment benefits, or if they ask us like, what are the income requirements? And then once that application is submitted to the landlord and the income is too low, how do we let them know why they got declined? When income
The landlord is not required to say why they declined the tenant, except they cannot decline a tenant for any of the 17 protected classes we mentioned before. So if you have a tenant that makes an application, if your landlord has set an income requirement in advance, that could be applied to anybody that has an income. But if somebody has an approved voucher for a rental amount, then the income restriction goes out the window. So for example, the landlord says I want somebody with 40 income of 40 times rent roll. You can ask for that if the person's working. But if the person is not working, or they are working but they have a voucher, then the income has no bearing on the application. And that rule, that restriction, that requirement from the landlord no longer apply when it comes to this tenant.
Okay. I didn't know if we were still allowed to say we want 30 times the income or 40 times the income.
If they're working.
Okay.
Yes. But if they tell you, so as a matter of practice, if somebody contacts you and they say for an apartment, and you say, well, how do you plan on paying for the apartment? And they'll say, well, I have a voucher for $1,800 and the apartment is listed for $1,800, then you can no longer have any discussions when it comes to rental income requirements, which is why you'd never want to advertise income requirements unless a co-op board has it as part of the application. My recommendation to everyone is just advertise the apartment, nothing else. Every other information you'll need will come out in subsequent discussions or the application process. So just stick with the details on the apartment to get the tenants. And when you have the tenants that are interested, provide them a copy of the application, and then that rest of the information is going to be coming out as part of that process.
Okay. What about but what about for applicants that are on unemployment benefits? Is that considered like because that's not a voucher, but it's still a legal source of income, but yet they're unemployed. So does that change anything in the application process?
No, it doesn't. It's a source of income. Source of income is a protected class. If they're getting unemployment, they're still protected under source of income. So you must consider them if they have sufficient income to qualify.
Even though it's finite, the landlords can't reject them knowing that at some point that's going to end and they won't know if they'll have a job or not.
Correct.
Okay. All right. Thank you.
I know sometimes the information can be a little daunting in terms of the way they analyze it, but you know, the laws are the laws and we have to follow the laws. And if you have a landlord that wants you to not follow the law, then like I said before, you have to let them know you can't work for them. And it's as simple as that.
Thank you.
Okay. So,
Okay, next raised hand.
right, raise hand, or did you want to go off the chat?
Off the chat, I'm sorry.
So the next question is from Mark, and it's regarding pets. So can you write no pets unless medically necessary? And then to piggyback on that, are service animal and emotional support animals even considered pets?
Well, they are, to answer the second question first, they are considered pets, but they're approved, they're required. So you can't deny somebody based on the fact that they have one of those. So the first question was, are you referring to the ad, Mark? Or is this Mark Cisternos?
Yes.
Mark,
Yes,
pop
this
over
is.
here, Mike.
Hey,
Oh my
what's
God,
Mark.
Santa Claus. Look at you.
up?
You know,
Ho, ho, ho.
Christmas is over.
Christmas came
Go
late.
back to the. Okay, what was your question?
Okay, actually, I have quite a few about this pet thing. So my question was, because I'll mix
Well,
it in with a question.
keep it just to this one, so this way I can go through.
Oh, I know,
to the
but I
other
have
ones,
a follow-up pet one and like 4 lines down, so I might as well just cut them both, and they're related.
Okay.
So what I was asking was, in quotes, can we put no pets unless medically necessary, quote unquote, in the ads? The only reason why I ask this is because, say, Street Easy or any of the other rental websites, they have boxes that check off for pets or no pets.
Right.
So I mean that, you know, plus we want to weed out people like crazy because
The law,
you know.
the law is clear. You can say no pets unless medically necessary. So if you put the ads no pet, and somebody contacts you and they say, you know, I have a service animal or emotional, medically approved emotional support animal, then the answer is yes, they'll be considered. So
Right.
to answer your question is yes, you can put that if you want. If you know,
I just want to weed out. I just weed out it with people, right?
If you put no pets, you can put it within the body of the ad, emotional support animal and service animal is
approved.
welcome.
Yeah. Oh, well, and actually, just because I do have a co-op sublet with this whole co-ops they cannot have any loopholes around that, right? Even though they have a strict no pet policy, they have to accept emotionally support or all that other good stuff, right?
Co-op boards have an application, and as you know, co-op boards can take the application. They can deny somebody without letting them know the reason why they're being denied. If they have a strict no pet policy and a tenant makes an application that has the circumstances where they have a pet under those 2 guidelines, the board has to consider the application, and then they can determine how they want to address it.
Okay.
But
Great.
you'll be out of that equation. It will be up to the board.
Okay. Cool.
Okay.
Thanks.
Next chat question, Christina.
Chat question or next?
I'm sorry, raise hand.
Vincent?
Just go in the order. I'm not keeping up, so just go
Got
in
it.
the order.
Vincent, you're next. If you want to go ahead and unmute yourself, you raised your hand.
Hello, how you doing? I'm pretty new, as Christina know, but who's required to do the background check? The listing agent or the tenant's agent?
if you're the tenant's agent, you'll be doing the background check because you're going to be making that application with them. So you, as a tenant's agent, you'll be providing the paperwork to the listing agent to get it done. So you'll be doing the application and the background searches. You'll send them the links to follow the steps to do the background searches and provide that to the listing agent. If you're the listing agent, then obviously, and you're taking a tenant on one of your rentals, then you'll be facilitating that process also. So it depends on the circumstances and the situation.
Okay, so I'm doing a background check and giving it to the listing agent, correct?
Right. Well, I don't want you to say you're doing the background check because you're not. You're providing the information for the tenants to follow to do the background check. So I just want us to be careful with our words because saying the words the wrong way sometimes can get us in trouble.
Okay, gotcha.
Gotcha. Okay.
Here. So in regards to the pet situation, I don't know if you answered it already, but again, are service animals or emotional support animals considered pets? And then also, what if a tenant offers additional money for having a pet? That's what Trudy asked.
A tenant cannot offer additional money in form of deposit for a pet because it's against the law. Landlord cannot accept that. And the answer is yes. As a matter of practice, I call them pets, but I guess legally they're not pets in the sense of a choice or an option. So if you want to separate the two and say they're required as part of the tenant's occupancy, then that's different. But I still call them pets. I don't think it matters either way.
Hey, Shamir, I actually asked that question regarding the pets and the companion. I remember from one of the classes back in the day where I think David Lagaz was teaching it. Service animals, the emotional support dogs, are considered companions, which is a separate category as pets. So when you're advertising the rental as no pets, service animal emotional support dogs are not in that category. So I just want to make sure.
Correct. Yes. No, correct. No, you're right.
Advertise.
So in other words, the law is clear. If you advertise no pets, those are the exceptions that we know. And those are the exceptions if somebody were to contact you and say, hey, I've got this dog, or I have this service animal, then the automatic answer is, of course, they're welcome.
Okay. So in that case, that we can advertise no pets because they are not pets.
Yes, in the sense of that, yes. So
Okay.
I'm sorry, I didn't understand the question fully, but correct. You can advertise no pets. If you want to be extra careful and put within the body of the ad, that's, service animals and emotional support medically approved as are allowed. That's fine. But the law is the law and the law is clear. So you're not going to be breaking the laws if you say no pets. You'll be breaking the law if you deny somebody the right to be in an apartment because they've got a support animal or medically approved animal or a service dog. I'm sorry. Okay.
Mark, did you have another question? I know you raised your hand. I don't know if it was you.
Mark Cisternos.
Yes, I can't get enough of you, Shamir.
Mark, if you don't, let me
It's an
jump ahead
agency one.
Okay, let me jump ahead to the other folks so I can get everybody a turn and we'll come back.
No problem.
So I have Donna Tom next. Donna,
Okay.
want to go
Hey,
ahead?
Donna.
Yep. Hi, Shamir. Happy New Year.
Happy New Year. How are you?
Good, thank you. So, I have a great landlord, but, he definitely cares about, income and making sure that the tenants can pay the rent. So if he keeps a standard of 40 times rent, again, across the board with everybody, right? I know with NTN, they do a background check, but they don't really do a credit check. What type
They
of...
do credit scores. Their background includes a credit score.
Okay.
All you can ask for when it comes to a background check is a credit score. You can look into their history when it comes to judgments and things of that nature. Past evictions is not allowed, it's against the law. So they will do and provide a credit score. Now, if your NTN search doesn't show a score because there's a conflict or there's an issue, you can ask the tenant, hey, the search didn't come back with a score, what's going on? And then you can further evaluate their situation based on those questions.
Correct. So a score, though, does not reflect ability to pay. They might have great credit. So in terms of the 40 times rent, making sure that the prospective renter has the income to cover the rent. At one point, we used to be able to ask for, if they're working, current pay stubs, W-2, Is that still allowed?
Of course, yeah. If the
Okay.
person is working, you're allowed to have them fill out the application and provide all that information: W-2s, tax returns, pay stubs, bank statements, ability to pay. The only exception to that is if they have an approved voucher or another source of payment. It could be somebody that went through a divorce and they have a settlement and an approved alimony from a spouse that's in writing. That could be a source of payment that's protected. So you can deny somebody an apartment that has an approved alimony that shows for rent, that shows they have the ability to pay the rent, or someone that has a voucher, someone that has an insurance settlement, some sort of annuity that shows they've got income coming in. So you could be somebody that's retired with no income, but they have sufficient resources showing they have an ability to pay, then that's allowed. So you can't deny somebody just because they don't have any income. You have to look at the entire package and see what else is there for them to show as the ability to pay. That's really the key.
Got it. Now, the question is also with vouchers, right? So let's say the apartment's 2,600, the voucher's only good for 2,000. Now, in that scenario, if there's a remaining $600 per month to cover the cost of the rental, what questions can be asked to see how that person would cover that remaining 600?
So if a person's only approved for $2,000 in a voucher, then it is illegal for them to pay you separately to make up the difference in the apartment.
Okay.
So if your landlord is asking 2,600 and they have a voucher for 2,000, with the exception if they have a working Section 8 or working program where they're required to pay up to 30% of their income towards the balance of the rent. So in other words, if 30% of their income that they make because they're working covers that $600, then you can consider them with the voucher. But if the voucher is not a working Section 8 or a program where they contribute towards the rent, then their rental ability caps at 2,000. So if your apartment is at 2,600, you cannot do a side deal for cash for them to pay the difference. That is against the law, not allowed.
Okay.
So the answer would be simple. If your apartment is 2,600 and somebody contacts you and said, I have a voucher for 2,000, you'll say, oh, I'm sorry, you don't qualify for this apartment.
Thank you.
Okay.
Shamir,
Christina?
right. So this is regarding rentals again. I think, I'm not quite sure if I get the question. JXR, I think it's Jimmy, right?
What time was the question?
It was at 11:32, and he said, what about if you have a couple with a kid under 5 years old? And this is for like a studio apartment.
So a studio apartment, for all practical purposes, when it comes to HUD guidelines, is considered to be the same as a one-bedroom space. So if you have a couple with a young child, technically they're not supposed to be denied the ability to rent the apartment. You can't advertise that apartment saying no kids. So again, going back to my recommendation, my strong recommendation, only advertise the details of the apartment. Chances are if somebody has a couple with a 5-year-old child, they're probably not going to be looking at a studio, they'll be looking at a one-bedroom. And a one-bedroom situation is something where the 5-year-old gets into the gray area of the occupancy space, but they can't necessarily be denied just based on that.
Shamir, is 5-year-old the cutout age?
There's no set cutoff age. Usually the recommendation is an infant child or a toddler. So that's probably about 2 or 3. It's kind of the norm where they could be allowed to reside in the same room as parents. It starts to get a little different as you get up in the age. There's no set cutoff age. So it's hard to give a straight answer when it comes to that. It's just kind of based on what the needs of the tenants. I do find that tenants that have an older child, like a 5-year-old, generally are not looking in a one-bedroom because they want to have the extra space. So they may not be as a common of a problem when it comes to that situation.
Thank
If you do run into that, though, that situation where you're not sure about the cutoff age or it's get into the gray area, before you answer, you may want to reach out to me. We can double check with the legal counsel just to make sure we know where we stand when it comes to answering that question.
Thank
It
you.
never hurts to pause before you answer, and it's okay to say, I'm not sure, let me check.
Okay, so next we do have Christine who raised her hand. Hi, Christine. If you want to go ahead and unmute yourself.
Hi,
Where's Christina? Hey,
how are you?
I'm good. What's up?
I'm brand spanking new and we
Welcome.
haven't yet, so nice to
Are
finally
you in Bayside or Jackson Heights?
Jackson Heights.
Okay,
Okay, great.
we'll be
So
nicer to you.
I have a series of questions. I don't know if this is the right medium
Is it
to ask.
regarding rentals?
Yeah, it's all rental questions.
How many questions do you have?
About 7 or 8.
We're going to take 2. We'll give other
Mhm.
folks some chances. I can
Mhm.
always take it offline afterwards, Chrissy, and
Mhm.
address the rest of them for you.
Okay. So do you guys have a standard app fee? And if so, what is it?
We went through that earlier. It's $20. It's part of the. Were you here for the start of the presentation?
I think I came in a few minutes after you
Okay,
started.
yeah. So there is a law pertaining to application fee. It's $20 maximum per individual. When the slide comes out to you after the class, it's actually detailed very clearly in that, so you'll be able to get that information clear. But to answer, quick answer is $20 capped per person, with some exceptions.
So maybe I'll grab the slides when you send them out, and then if I have any other questions, I'll
That's a
ask you.
great idea. Yep. Well, I mean, you can go one more if you get something else that you think might be helpful to the audience.
Okay. Well, for deposits, do you guys take a cash deposit? And if so, like for the remaining payment when you do a lease signing, are you guys recommending that we have the payments made out to us and then we pay out the property owner, or paying directly
So
out?
yeah, so these are obviously both questions we're also went over. So I'm glad you asked them anyway. Some people may have missed them. The quick answer is cash deposits are allowed. You have to give a receipt to the tenant, and it must be given to the office right away, or to the landlord if you transfer in the apartment. Taking care of the rental. And what was the second question? When it comes,
When you're doing the signing.
Mhm.
So are we required to accept the entire payment in-house and then pay out the property owner? Or are you okay with the tenant directly paying the property owner?
Simultaneously, but you need to have proof of the payment. So if the tenant pays the landlord directly, receipts are important, or copies of the checks or whatever it is they use. So tenant pays the landlord, tenant pays security deposit to the landlord, tenant pays you. If the tenant's paying you the commission, which we're still allowed to collect commission from tenants, but that might go away eventually. Currently, we're allowed to do so. So once documented, we don't have to collect it in-house. If it's given in-house, you can simultaneously have the checks made out to the landlord and the checks made out to the office separately. They have to be certified or some sort of certified funds.
Okay.
Okay, Christina, next one.
So the next 2 are about programs, I believe. One is, what if it's a landlord who's working with government programs, states this apartment is for single occupancy residents? Is this allowed to be stated? And then also Stefan asks, what if the room rental is an apartment and it's an NYC program being used?
All right, so let's go to the first one. The question was if you can advertise single occupancy.
David, you had asked this question. David Louis.
Hi, how you doing? I come from a background from the Department of Homeless Services. I was a housing specialist for 14 years there. So the clientele that that they give vouchers to, or either on the family side or on the single side. So a lot of these landlords that ask for these single individuals always say single resident occupancy, SROs, when they advertise for renting an apartment. So is that legal to take?
SROs are not as common anymore. An SRO does not mean only one person occupying the apartment. I just want to clarify, is that what you're saying, or
Yeah,
are you referring to the SRO's status?
SRO status.
So if a property has a legally registered SRO, an SRO, for folks that don't know, is something that was very common a long time ago, where people needed rentals. So landlords were allowed to legally convert their properties into room and apartments. They're not very common anymore. And a lot of landlords have had their registrations to use as an SRO have expired. you're only allowed to rent an SRO, a single room occupancy, one room at a time, if the landlord provides documentation to show that they're currently allowed and up to date to rent as single room occupancies. If they don't have it, if it's not current, then the answer is no, you can't do it. You can't rent it.
I also have another question right after in regards to that also. So most of the people that I used to represent were single mother with same-sex child or single mother with a different sex child. Now, from what I learned from Department of Homeless Services, which was following the HUD guidelines and Section 8 guidelines, is that if you do have a child that is a different sex, they're not allowed to have another room until they turn 7 years old.
Okay, so that's probably somebody asked before about the cutoff. So that's a good clarification right there in terms of what Section 8 uses as their guidelines.
Right,
as
and
a
if
separate.
it's the same sex, like let's say it's a single mother with a daughter, they're
They can share.
allowed. They can share a one bedroom for like till the kid turns 18. I mean that's what we were taught in the government system.
That's a good standard practice that we can use across the board. I think in general, when a tenant has a situation of that nature, they're looking for the right scenario anyway. So they're going to be looking for, or they would have been approved for a 2-bedroom because they have a child of age that needs a separate room. So that situation probably wouldn't present a problem for us because the tenant will be looking for the situation to best suit their needs anyway. And they would have applied with the city or the state to get approved for that situation, that suits their needs.
Exactly. Thank you. I just wanted to clarify that because
Thank
that's
you,
what
David.
we were
Great
taught.
questions.
No problem.
Christina?
Shamir,
Guys, I know we're going to be going for a while at this rate, obviously with questions, but I do want to answer all the questions. So if you want to stick around, I really highly recommend you do. We'll probably try to get through this in the next 20 minutes. The goal was to keep this to 90, but we're probably going to go about 15 minutes over with your permission. So please stick around so you can get all the details.
So I still have Mark and Geraldine that have their hands raised. They're the last two people whose hands are raised. I don't know if perhaps
Well, let's go to, is there anything else in the chat that we need to go to first?
Quite a bit in the chat. So
let's run through some of those first. We'll come back to Geraldine and Mark. I don't really care about Mark Ciceranos. You can disconnect him.
Shamir prefers my million calls a week thing.
Let's go to a few questions in the chat.
Right. So Stefan had asked, what if the room rental is an apartment and it's an NYC program being used?
What is the what?
What if the room rental is an apartment and it's an NYC program being used? Stefan,
time is the question?
Hey, how you doing? I know you had said that that room rentals are illegal to rent. So I was asking if like a city program like City FEPS, because I had a few room rentals that I had did deals with.
And this is the city. This is the city paying the commission on the rental.
That's correct.
Okay. I mean, so in those situations where somebody is approved to only rent a room and the city is paying the commission on the rental, then that would be the exception that's allowed.
Okay.
If you have a landlord that's got 10 rooms and he wants to rent it out to individual people, you're not allowed to rent those.
Gotcha.
Now, keep in mind, whenever you're going to rent a room situation like that, typically that apartment's usually, the building's usually approved and inspected by the city for that purpose. So that's the exception that you have when it comes to, there's an overlaying agency that have already looked at this property and said it's okay for them to be able to do that.
Okay.
They've got the right, escape situation and safety and, shared accommodations, et cetera, et cetera.
All right. Thank you.
Sham,
Next chat question.
Mona Lisa asks, if a landlord declines a client due to an extensive criminal record, is that discrimination?
That falls into that gray area, Mona Lisa, that I mentioned before. That's, as I mentioned before, the criminal past is not a protected class. So that's a situation. I imagine, Mona Lisa, can you pop up on the?
Mona Lisa?
Yes, I'm here.
Okay. So would you be okay sharing
yes,
a specific situation?
So I had last week, as most of you know, I do vouchers. So generally, the caseworker will give a background, so we don't do a background check. But for this particular one, I didn't get a full background, so the landlord requested to do a background check. And when he did, he found, which the client agreed to, he provided the social and his ID. And he had constant arrests back to back for like robbery, armed robbery, assault, like a bunch of having weapons, different things. So the landlord was uncomfortable renting to him. And I know it's not a protected class, but I just wanted to be sure that it
I
was okay
think
for the landlord.
I think that situation would fall into where the landlord would be allowed to say no, given the active concern.
Right.
So if you wanted to, we can double check with the state attorney, but I'm very certain that that'd be okay. If you had somebody, just to expand, if you had somebody that had one arrest 20 years ago and the landlord denies them for that, then that's going to fall into the area. Mute me back, Christina. Christina, mute it back.
Yeah, I just muted her.
Okay, can you guys hear me? Thumbs up.
Yeah.
The landlord, in this situation with the excessive stuff, that would be acceptable to say no. In a situation where there's something in the past 15 years ago, that's a situation where you probably don't want to have the landlord say no based on that.
Right.
The background company that we use, they do the right checks and provide the right information in compliance with the law. This is why we want you guys to use that company, because it's going to protect your license and prevent you from saying or asking the wrong things that violates the law.
Right. Thank you.
You got it. Next chat question, Christina.
This one is from, sorry, in regards to open listings, what is the incentive for landlords to sign agency disclosure agreements?
It's the law. Let them know that we need to let you know in advance who we're representing. And since I'm advertising your property, even though you haven't signed a listing with me, I'm still representing your best interests. Because a tenant that contacts me is going to assume that I'm representing you because I'm advertising the listing. So you need to sign the agency. And the fair housing protects you and him because it allows both of you to disclose to the tenant that you're not violating any of the fair housing laws. If you have a landlord that refuses to sign those documentation, don't advertise that apartment. You're just looking for trouble because they may say or do the wrong things in front of the tenant that's going to call to your license. You know, our license is worth a lot of money over a career. I've been doing this for a long time, so I can tell you for a fact that no deal is worth risking your license, ever. If you get somebody that says the wrong thing, or you think they'll say the wrong thing based on their personality or what they're saying when it comes to the landlord, then just walk away and get another listing or advertise another apartment. Don't jeopardize your license or our license as a company.
Okay.
Next.
And then those who asked, yes, we are going to send this out. We'll go ahead and email these slides afterwards. The next question from Lewis is, it might be a legal question, but what about those tenants who are collecting unemployment only? Is this a lawful source of income?
It is a lawful source of income.
Okay.
And if they have sufficient income to qualify, then they have to be considered as individuals when it comes to qualifying for the apartment.
Is it illegal for a landlord to tell you they do not want to rent their 2-bedroom apartment to any person because they don't feel comfortable and desire? Sorry, I'm trying to read the message.
What time is the message on?
11:51.
Is it legal for a landlord to tell you they're not going to rent a 2-bedroom apartment to one person because they don't feel comfortable and desire instead of for a couple? So if they have a 2-bedroom apartment, they'll have an income requirement. If the individual does not fit the income requirement, then they can say no to them. But they can't say no because the person is one person that wants to rent a larger unit. If they qualify, they qualify. So to answer the question, it's not illegal for them to say no if they don't have sufficient income. But if they have sufficient income to qualify, then they can't say no to them.
And then this question, I'm pretty sure I know the answer to this one. What happens if the prospective tenant asks the agent what kind of people, like what ethnic, background or ethnicity?
Never,
That's a
ever,
no. It's
ever,
always a
ever,
no.
ever, ever,
Yeah.
ever, 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 ever have a discussion about ethnicity when it comes to who's living next door. If somebody asks you who's next door, it's like, I'm sorry, I haven't met them, but you probably would when you move in.
Yep.
Or I don't know who they are, I don't know where they're from, but they seem very nice. I said hi to them all the time. We never want to get into discussions when it comes to the ethnicity or anything along the lines of somebody. It's just not a discussion we should be ever having, especially with what happened with Newsday last year. That should be an example for all of us to make sure we're extremely careful what we say.
Can I chime in on this, Shamir? Because I do this all the time. Because I'm a listing agent all the time.
You
with
break the
rentals.
laws all the time?
Always.
Okay. No.
I actually pull out, and I think they respect you more. I pull out the I'm sorry, fair housing law prevents me from discussing anybody living in the building.
Awesome.
Exactly what I say. And they just say, oh, okay. And then it kind of gains their trust that you're a person of integrity anyway. So it's kind of twofold.
Next time we'll have Mark teach his class. Obviously, he does a better job than I do.
I
That's
don't
a
know
great
anything about
answer.
pets.
That's a great answer. Fair housing laws do not allow me to discuss anything about the ethnicity or who lives next door, and then just leave it at that. Keep the answers short and then move on.
Okay. And then how can we ask how long vouchers gonna cover? How long are vouchers covered for?
The approval will be on the voucher. The city usually has how much they're approved for, and typically, Mona Lisa, can you pop back up? You may have the answer to this one.
Does it
Yes.
expire after a certain amount of time? Like, is there a certain?
There are
period?
different ones. There are some vouchers that will pay the full year's rent, but they only pay for the 1 year, and then the client is responsible to pay with their own income thereafter. There are some where it's forever. Like there's a program HASA. It's for clients with HIV and AIDS, and of course that's a forever disease. So that program pays forever. It just depends on the situation.
Okay, but it's usually you would know up front at the start what voucher it is and what it covers, right?
Always
Or how
ask
long
the
it covers it for?
caseworker.
Okay, perfect. Thank you.
Evans asked if we are using a new office application or MLS rental app. Missed the beginning.
We have an office application that's compliant. The only thing on the application that's there, it asks for additional occupants of the unit. They'll be occupying the unit. If the person has kids, that information section is now required to be filled out. So you need to let the tenants know that if they have younger children, they don't need to put that information on the application.
Donna, I don't know if you've already had this answered, but it's
did.
in regards
Yeah,
the
it's
40.
it
She did,
was
yeah.
answered. Thank you.
Jam, are you looking at it?
Marlena asked about credit score. The answer is yes. They can have a requirement. That requirement must be the same for everyone. So they can make exceptions based on the application. I usually recommend, the landlord just, have the application be submitted for a tenant that has the right requirements and then make a decision based on that. But if the landlord wants to have a requirement in credit score, they're allowed to do so. But it has to be applied across the board with everyone. You can't make exceptions because somebody has more income. You can't accept somebody who wants to pay higher security deposit because their credit score is lower. That's not allowed.
Okay, and then also Donna's question about the support animals. There's a side.
There's no size limit, Donna. If they're approved, they're approved. I don't think they're approving. I don't think they're approving alligators or Mike Tyson's tigers. So I think it will be okay.
And then Claude asks if a owner requires a credit score of 680, can he still ask for that when the potential tenant has a voucher?
No. I'm sorry. Yes. Back up. Yes, you can require a credit score even if the tenant has a voucher. But generally, if you're going to consider a tenant with a voucher, then it's not so critical, obviously, in terms of that situation. But you can have that standard.
Okay. And then Julie asked if the voucher is enough to cover rent. What about utilities? Can they reject it? Because because they can't provide financial support for the utility costs?
That's a great question. Mona Lisa, I'm gonna lean on you one more time on that one.
That was actually Julie that asked that.
No, I
So
know. I
you
wanted
said
to see.
about the utilities?
Yes. So the question was vouchers enough to cover the rent. How about utilities? What do you typically see with your voucher rentals in terms of
Okay, so
utilities?
what I do, there's always like loopholes with the voucher rate. So let's say the voucher only covers $1,600, but if the landlord is willing to add all utilities included, then the caseworker may request that the voucher be able to pay $1,700 in rent. So that way the landlord is compensated for the utilities as well. So anything you want to know, you always want to go to your caseworker and see what can be done.
Perfect. Thank you. John Hen had a question. Does listing agent landlord have to accept background check you provide, or can they assist your tenant use their background check and service? They can insist, John Hen, but that background service must follow the law, which means cap on the application fee and restrictions on what searches they're allowed to do. Different states have different regulations. New York State's got a certain set of regulations we must follow. So that company must be approved to provide a background search within the New York State background search laws. Does that answer your question, Mr. Hahn? He might have left.
Okay.
Can you hear me?
Yeah, I can hear you. Does that answer your question?
Well, the reason I was asking is because you had mentioned the background check service we use. They run a credit check. And so if they're running a credit check and a landlord doesn't want to accept the service that we're using, then it seems like they're going to have to get their credit run multiple times. And so I'm just trying to avoid that situation.
Right. So which is why you want to have the conversation in advance. So if your landlord's saying, I don't want to use your company. So if you're taking a listing with the information we're providing today and the access information you're going to have, you should be having these discussions with your landlord pertaining to protect the classes, non-discrimination rules, the laws, security deposit rules, et cetera, we have to follow.
I was referencing if we had a tenant that we were showing a property to. And so you said as part of the process, we should get the background check,
Correct. So if
filled
before
out
you
prior
submit
to
the
showing them around.
application to the other the listing agent, you'll ask them, you let them know we have a service. This is the service. Would your landlord accept this, or do they have a service they want us to use? If so, provide that information so the tenant can run it. So you can do it just once, not twice. So that's a question you ask before you submit the application.
All right.
Gotcha.
All right. Thank you.
Mark did have a question. I don't know if you want to pop in.
Well, wait a second. What's her name? Had a question before Geraldine. Did you skip her for a while?
This close.
Where are you?
Mark, stop hanging the calls, Mark. You get me all the time anyway. Go ahead, Geraldine.
Thank you. Shamir, I wanted to ask you, what is the difference between advertising like we want 1 month's rent and 1 month security versus 1 month's rent and 1 month deposit? Are those the same thing or are they different?
Well, they're the same thing. The deposit and security is the
security
same. So.
And the deposit?
It's the same.
Oh, okay.
So, I mean, again, you don't want to, getting back to the advertisements, those are discussions you can have when somebody contacts you, what's required, stick with your ads with the details on the apartment only. Don't start restricting, in the ad language, what you want and what you don't want, because it's just going to lead to situation that you might say or write the wrong things that causes a lot of headaches, and it's going to be in print. So it's going to be publicly available for somebody to be able to have it as proof. So run the ads with the unit, and when somebody contacts you, they'll naturally ask you what's required, and you'll say, well, with the law, 1 month security deposit and the first month's rent before you move in. And then if you're charging the tenant the rent, then the commission, then that has to be disclosed at first contact. But if your advertisement is for a no-fee apartment, in other words, the landlord's paying you the commission, or you're working for free, I don't know why you do that. But if that's the situation, then obviously you disclose that at first contact with the tenants. Okay,
thank you.
Go ahead, Mark. Go ahead,
Don't.
Mark. Okay,
all right, I'm here.
ahead.
All right, guys, relax. I only have one question, but it's broken up into
that was
24
5 questions
parts.
ago.
No. Okay, so really quickly, on the agency disclosure form, I usually, because I do open or a listing agent stuff, so I check off the listing side always. But now you're telling us to do advanced agency consent
Advanced
with
informed consent to
designated.
dual agency. Yes.
Always
And the
have
reason
that.
for that is the reason for advanced informed consent is the following: if you're showing a listing in the office, or a tenant is being represented by another agent within the office
From KW, okay.
from KW Landmark 2,
Right.
the office you work in, technically everybody in that company is representing one person or representing the landlord if it's listed within a company, with the exception of the advance informed consent to dual agency, which is why you need to let your landlord know that, hey, there might be a situation where Mona Lisa may have a tenant she's representing, and I'm representing you. So she's going to fill out this form with the tenant that says, I'm representing Mark, the landlord. She's representing Mr. X, the tenant, which is why that form is going to be there.
Okay, so
Okay.
but you know, Mona Lisa still just looks out for the tenant, and I still look out for the landlord, right? Nothing
Correct.
changes there. There's no
Nothing changes
neutrality.
there. No.
Okay,
Nope.
awesome. There was that, number one. Number two is really quickly.
No, number two, we're going to cut you off.
I mean,
Move
1A, 1A, 1A. No. Was back to because I remember reading the Tenant Protection Act of 2019. Was that if a tenant comes with their own credit report, we are supposed to accept that as opposed to being
Correct.
able
And
to
we
do our own
touched on that
background
also.
check.
If a tenant provides you with a credit report or background searches within 30 days of the application, then you cannot charge them the fee for the rental.
Oh, but
if your landlord still insists on getting another background search to be done, they're allowed to ask for that, but they cannot charge the fee.
Okay, they're allowed to ask for it, but the tenant says no, screw that. Then the landlord could say, well, I'm not going to rent to them.
Correct.
Okay.
If they have questions or concerns about the legitimacy of the background search provided, landlord can request their own, but they can't charge a fee.
Yeah, because I can't get a PDF from somebody. I mean, I know how to doctor PDFs. Not that I've ever done it.
So just let's not admit to our crimes online, Mark. This has been recorded. If you're going to get a copy of a background search from a tenant that's done on their own within the last 30 days because they had it done prior to with another rental they were denied for, then you can simply request them to send you the link, like you would normal from the company directly, so that it can be authentic. If that's the situation, then there'll be no need for your landlord to do a second one because it's coming from an authentic source like NTN or one of the agencies that are allowed to do so.
Right. Okay.
So
cool.
no PDFs, no printed copies. It'll be a lot easier that way.
Sounds good. Thanks, brother.
Okay, 5 more minutes, guys. If we can get through the questions, that'd be awesome. I'm willing to stay longer if you've had other questions. I want to make sure we're all clear on these because this is critical to make sure we practice business the right way. Go, Christina.
We do have Nicola who has her hand raised. However, Michael Gal also asked a question in the chat. Sham, if you want to look at it, it's a bit long. Sorry, Michael. There are some applicants who want to pay rents upfront 6 to 12 months in advance to the landlord because they don't have credit or income, international students. As a follow-up for the undocumented applicants, they don't have SS, Social Security and credit. Can landlord reject their application in this situation? Would it be against the law to reject them because they are undocumented?
So if you recall, under the protected classes, legal status was one of them for New York City. So Michael, to answer your question, if you have somebody that's not a resident, not a citizen, they can be denied the rental. If they want to pay rent up front, that's allowed. What they can be required to do is to pay additional security deposits more than 1 month's rent. And even if they're not a citizen, if they're an international student or they're illegal, the laws still protect them in New York City and New York State.
Hey, Shamir. So landlords can't allow to collect multiple rents upfront from the tenants if they're willing to do that, right?
Correct.
Okay.
They're allowed to do so, but they're not allowed to require. In other words, the tenant can say, I'm willing to do this, and they can ask for it. But the standard has to be applied to everybody.
Right.
in terms of the situation, but they're not allowed to say you have to pay me 6 months of security deposit.
Right. The follow-up question I rented this multiple times because tenants reject applicants because they don't have credit report. But if the applicant is people who doesn't have social security numbers, I mean, there's no way I can get them the credit report. So that translates to me that they are discriminating some of the tenants that wants to get the that wants to apply due to their legal status. Is that a violation?
Well, if you deny somebody based on the finances, that's fine. So I mean, if they say no to somebody because of their credit history, they're allowed to make a decision once the decision is the same across the board with everybody.
Okay, I'll dig into it. Thank you.
Gotcha.
And Nicola, you're next. I know you have your hand raised. Thank you for patiently waiting.
His hand must be hurting. Her hand must be hurting.
Hi,
Raise it this long.
Shamir. Hi, Christina. Okay, so I've never rented an apartment before. However, what is the procedure when you're find a client and they want to rent something?
Are you asking the process to rent the
Yes.
apartment? You know, to find the apartment?
No, to rent. I know you look on the MLS
Right,
and you
right. Okay.
see. Yes, I know all
Well, I
that
mean,
process.
to keep it brief, you show them the apartment. If they're interested and they're qualified for it, either in the form of an income to qualify based on the income requirement the landlord has, or they have a voucher or an approved source of payment, then and they like the apartment, then you submit the application, whatever the landlord's agent's asking for, or the landlord, that's legal. Nothing illegal can be asked for, and then they can be considered, and then you can, once they're approved, then the landlords can provide a lease and have it signed.
Okay, so it's pretty simple. Just follow the rules.
Pretty simple.
The
Follow
law.
the rules. Don't speak out of turn in terms of information. If you're not sure, don't assume. Don't ever assume. Don't rely on some myth, some information you heard 20 years ago, something that you heard from somebody else. We're the source. The attorneys that we have as part of our associations are the source for information that you're not sure about. I've covered a lot of the items today that's on the list.
I heard.
You're going to have the slides, but if you guys are ever unsure about something, it is okay to say, I'm not sure, let me confirm. Check with me, check with the brokers, check with somebody that knows, or call the attorney, get the right answers before you speak.
Okay, so we just get the form, the background form from the office. I mean the web, and let them do that on their own.
Correct. Yes, there's going to be a link was sent out with the instructions, and there's an attached form that gives them the information which they have to follow to complete the background search. And then once it's done, it's emailed back to them, and they can provide a copy to you with the link.
Okay, great. Thank you. Oh, one more question. If there's on the listing in the MLS, they have for compensation $1, what do you do as an agent where that is concerned?
So if the listing has compensation that's really low or no compensation paid out to a tenant's agent, like you'd be in this case if you show in the apartment, then you need to let the tenant know up front that I'm representing you and you'll be responsible for the fees.
Okay, so will they be paying the fee to the landlord plus a fee to me?
They'll be paying the security deposit to the landlord and the first month's rent, and they'll be paying a fee to the agent.
Okay.
Which in this case would be you, yes.
Okay. Thank you.
Now, we're still allowed to legally collect fees from tenants, but that case is in court. It's probably going to come up for a hearing sometime soon. So we're going to inform you guys if it changes, and if it does change, then unless you're representing a tenant, you won't be able to charge a tenant the commission the landlord will have to pay. But we'll let you guys know if that changes.
Okay.
Let's get a few more before we wrap up. Are you guys tired? I'm hungry.
Shamir, quick question, just to clarify something with the last question.
Who's this?
This is Evans.
Oh, my man. What's up?
Happy New Year. Question regarding the last question.
How's Dean doing?
He's on here somewhere.
Okay.
The client basically that's paying the tenant agent, that check is going out to not the actual agent, but to the office, right?
Correct.
Okay, just want to clarify that.
Mm-hmm. Yeah. Made payable to the office or transferred to the office via electronic or cash, payable to the office. Now, there are cases where the tenant's paying the commission, but the commission's been split between the listing agent and the selling agent. So you have to make arrangements if you're representing the tenant to get that done, where it's separated the right way.
Okay, gotcha.
The bottom is agents is we're not allowed to collect monies directly to our name, checks to our name, or monies transferred to our account. That's illegal. That could cost you your license. You're supposed to have arrange for the money to be sent to the office directly. You can get that information from Susie in terms of the transfer or certified funds or cash.
Okay. So we do still have Anastasia and Geraldine and Donna that have questions.
Okay, let's go with Geraldine. We haven't taken her for a while. Go ahead, Jerry.
Hi, Shamir. This is my last question. It's a two-part question. So right now I have a rental on Woodside, and I'm using a website called Pre-Approved Renter to screen applicants. That website also, like, you can do a background check through that website. So I'm just confirming I can't use that anymore. I have to use TNT to do a background check.
NTN, yes.
NTN,
Because
right?
we don't know if they're compliant with the laws.
Okay.
And so there's something that we just need to be really careful with. These are the small nuances of rentals that can cause you a lot of headaches. So we've screened and looked at this company, NTN, very carefully. We've gone through all their compliance steps that they require as part of us practicing and using them, which is why we want everyone to use them. There's no benefit to you to use somebody else that we haven't approved. It's just a risk that's going to put you and us in a bad position if they don't do the right thing.
Okay. And then the second part to that question is when I use pre-approved renter, I noticed that the $20 goes towards the credit background, but not the criminal background. So who's responsible for covering that cost, the owner or the agent?
Well,
Or
let me ask you to answer the question. If the limit is $20 that you can charge him, who will be responsible?
All right, so it's not the tenant, but would it be
Correct.
me or the owner?
Which is why you want to use NTN, because they include the background searches and credit searches for $20.
Oh, okay, cool. All right, thank you. I appreciate it.
Anastasia, Donna, we have you on. I don't know I think Anastasia was first and then Donna.
Anastasia?
Hi, I have a question about when a tenant wants to use a guarantor. I have an international student who wants to use his uncle as a guarantor, but the uncle currently doesn't have income because he just retired. So my question is specifically, what can I legally request from the guarantor, and like what can I say to the guarantor?
Well, if the guarantor doesn't have income because they're retired, they probably still have source of income like retirement, annuities, pension, Social Security. So there probably are filing tax returns, or they have some sort of source of income. So you can request that information as part of the application.
Okay. So he's just, not to spend too much time on this, but he specifically told me that he hasn't applied for Social Security yet. And and he's a little reluctant about me checking.
Well, does he have a source of income in terms of like an approved voucher or something they have to pay the department?
No, I'm talking about the guarantor. No, and the other one, the tenant himself, his parents are going to be paying from another country. But I don't have a way of verifying that. Like, is there any way I can legally verify that, or?
There isn't. There isn't anything you can legally verify in that situation. So if they want to prepay their rent, that's acceptable in terms of the landlord. If the guarantor has no income, why would you even want your landlord to consider somebody that can't prove their ability to pay? So to answer your question is, you can legally tell them, I'm sorry, you don't have a way to prove you have the income to qualify, so my landlord's not going to be able to consider you. It's as simple as that. And unless they have a voucher, you can require that they have a certain amount of income to qualify for the unit. The landlord has that right to be able to do so. So you can ask them whatever you need for them to provide to show that, and if they can't, then you can say no to that person.
Okay.
Or have them prepay the rent, not a security deposit, but the rent in advance.
So just to be clear, asking what can I ask the guarantor for? A W-2? What else?
Of course. You can have them fill out the application from the office that gives the list of everything they need to provide, which will include W-2s, tax returns, pay stubs, bank statements, proof of ability to be able to pay the rent.
Okay. Okay, thanks.
Hey, Shamir, I
Christina?
have a quick question if there's nobody else.
Sure, go ahead, Rob.
So I thought I heard wrong. Someone could pay if the landlord allows it and they don't have credit or income, they could pay the rent for 1 year in advance?
If they want to, yes. It just can't be a security deposit, that's all.
Okay.
Security deposit are capped at 1 month, but somebody wants to prepay the rent, then they're allowed to do so. The landlord cannot require that somebody prepay their rent, if in terms of the situation, like they can't demand, I'm only taking people that want to prepay their rent. But if somebody has the ability to pay and they can show they have the means to pay monthly, then that should be acceptable. But in situations where somebody wants to because they have a situation where it doesn't allow them, then they're allowed to do so. It just can't be a security deposit. Landlord cannot say, hey, you need to give me 6 months security deposit to guarantee me you're not gonna, be able to pay that. So in other words, the rent has to be prepaid and deducted monthly, not a security deposit that's reimbursed after 6 months because they paid on time. Okay?
Got it.
Okay. I have a quick question, Shamir.
Mm-hmm.
Shamir, I never heard about this national tenant network. We used to go to some other.
Are you in Bayside or Jackson Heights?
Bayside.
I don't know if Bayside is using them. They might have somebody else that they approved for. We got them approved a few months ago. Actually, we got them approved early last year, but with COVID, it got delayed. Check with Gloria to see who they have recommended in Bayside. They may have the same, I'm not sure.
Yeah, okay, we got those. I think they're still using some other company. I forgot.
Okay, that's fine. Yeah, whatever they have approved, it's what's going to be acceptable. We in Jackson Heights, we have NTN approved as the company that does the searches for us.
Okay, no, why? Because the one we're using in Bayside, I think they only do the credit check for 20, and then the
Okay. Well, the law is so if there's a background checks that need to be done that's above that 20, then the landlord will have to pay that, or you pay that. The tenant cannot be charged.
Thank you,
Nicola.
Back to the question I had before about collecting the commission. How much should the commission be if there's nothing there to add?
There's no fixed number when it comes to a commission. A commission is the amount that you and your client agree upon in writing of what the amount is going to be.
Okay, even
in general
on
in
the
practice, right? General in practice in rentals, it could be 1 month, it could be 10% of the annual rent, it could be 15% of the annual rent. A commission can never be fixed. You have to agree between yourself and your client what the amount of the commission that you're going to charge and that you're agreeable to pay.
Okay, thank you.
You're welcome. Any more questions, guys? You guys have been patient. Thank you so much.
It's Donna. I do actually have one more question, if you don't mind.
Mm-hmm.
So I've been working with the same landlord for several years now, and he's given me multiple agency disclosures, certificate of occupancy, lead paint. Do I have to keep on asking him each time for the same documents? Like I get a rental, let's say, twice a year. Yeah.
Right. Agency is specific to the individual. Lead paint is specific to the unit. Yeah. So if you're working with the same person, an agency would be applicable for different rental units. So would be the fair housing form from the same person, but the lead paint disclosure has to be specific to each unit that you're renting.
So if I rented the unit 2 years ago and he filled out the lead paint disclosure, right? Nothing's changed. Do I still need to get the same lead paint disclosure on the same unit, even though it's filled out 2 years ago? Or...
Well, I mean, you don't know nothing has changed unless you clarify nothing has changed. And the best way to clarify nothing has changed is to have him re-sign a new one, executed with the new date. And so technically, yes, you can use the old one, but how do you prove if the tenant moved in there and there was flake and paint and their child got sick and tested positive for lead paint? You don't have something current around the time that you rented the unit to show that you confirmed that. So yes, you can use an old one, but my recommendation would be to use, especially with lead paint, something very current. Fair housing and agency could be duplicated 2 years later, that's acceptable. I would still redo it anyway as a personal practice, But you can use those because it's the same. It applies unless the forms have been updated. But lead paint, I would highly recommend you get the current one signed.
Got it. How about certificate of occupancy?
Well, that doesn't really change unless there's a violation that says something to the contrary. So if you have a certificate of occupancy that says it's allowed to be rented because it's a 1-bedroom unit, then that stays on forever.
Okay, great. Thank you.
Mhm.
Okay, Shamir?
Yo, what's up, John? I'm sorry, Kate.
Yeah, my microphone doesn't work. It's funny, the last question I asked you, I almost heard none of the answer because my computer kind of broke down. But actually, I had a question in the chat. If I use the office tenant rental application, can I be certain that by using that application, I'm not violating any federal, state, local rules, laws?
The application.
Because I remember, like, I haven't used one in years, but I remember looking at it years ago. And there was a line item regarding income. And so because source of income is a protected class, and I've generally just tried to stay away from income related questions by handing out an application with that stated on there. I don't know what they state now because I haven't looked at one.
Right, so you want to check to make sure it's updated to the current law, but regarding that specific question, the application could say, have a line for income. If you're working with a tenant that's making an application that says that we've got a voucher, then in the email that you send out the copy of the application in, you can simply say you don't need to complete the income section because obviously you've already been pre-approved you already qualify based on the income, based on the voucher that you approved for. So you can add another layer of that in terms of your email to kind of cover yourself when it comes to that specific thing. But I'm sure they've updated their application. We've updated ours. I've looked at it. It falls within the law, and it doesn't ask for anything that's not allowed. So just double check, but you should be fine in that respect in terms of income. Just add that extra language in your email.
Okay, lastly, Shamir, Angela had said she's seen some rentals on MLS without the full address. I guess the listing agent is responsible to post the whole address, correct?
Correct, yes.
Awesome.
All right, guys, thank you so much. Now, keep in mind, we are going to be sending out the quiz. It's something that we want to make sure you grasp the concepts of what we talked about today. And you can take them multiple times if you need to. It's just a way to reinforce what we discussed to make sure we're getting it right. We want you to get it right because it's a way to protect your license while you make income for your livelihood. And for those that haven't or been able to stay on the entire class, you'd have to just sit through the video one more time to make sure you get everything correct and get the quiz answered. If you have any other questions offline, please feel free to reach out to me. In Bayside, you've got Gloria and Lou and other folks, but you can certainly reach out to me also if you want to. And just stay safe, do the right thing, and stay out of trouble.
Thank you, Shamir.
Thank you.
You're welcome, guys.
Thank you.
Have an awesome day.
Thank you.
Thank you, Shamir.
Thank you, Shamir.
Gracias.
Gracias. Au revoir. Sayonara.